Hello, my name is Jim Turk, and I'm the director of the Center for Free Expression. I'd begin today's session by acknowledging the land on which I am speaking to you today is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis. I also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaties, signed with multiple Mississauga and Chippewa bands. On behalf of the Center for Free Expression at Ryerson University, I want to welcome you to what will be the first in the Center for Free Expression's Fall Virtual Forum series. The title of today's panel discussion is Legal Protections for Whistleblowers: What is Needed in Canada? As I think you will hear today, an awful lot is needed in Canada, and it's of special importance as we're in the midst of a horrible and seemingly never-ending pandemic. The panel will be focusing on this matter of considerable importance to try to increase public awareness of this issue and the importance for all of us of having adequate protection for those who draw to attention, to public attention, problems in workplaces that affect the public. We have quite a remarkable panel to talk with you today, and let me introduce them. First, I'd like to introduce Ian Braun. Ian knows this issue firsthand as a former whistleblower himself, having raised serious concerns about Transport Canada's oversight, or lack thereof, of marine security. He is now a Ph.D. candidate at Carleton University, studying whistleblowing in Westminster governments, and just completing a remarkable and soon to be publicly released detailed comparison of whistleblower protection laws across Canada. Ian is also a senior fellow in the Center for Free Expression. Welcome, Ian.
Nice to be here, thank
you. The second panelist is Tom Devine. Tom is legal director of the Government Accountability Project in the United States, one of the leading whistleblower protection organizations in the world. In addition to having assisted over 7,000 whistleblowers and made a real difference on behalf of the public, for example, in helping shutter accident-prone nuclear plants, rebuffing industry ploys to deregulate government meat inspection, instituting a national commercial milk testing program for illegal animal drugs, and sparking the withdrawal of dangerous prescription drugs. Tom has made just such a remarkable contribution in that sense. Tom has not lost a case since 2006 and has prevailed in advocacy at numerous U.S. courts of appeals, as well as at the U.S. Supreme Court. He is also a leader in campaigns to pass or defend 34 national or international whistleblower laws. Tom has spent a good deal of the last several decades traveling around the world, assisting whistleblower organizations and civil society groups in numerous countries move forward in getting proper whistleblowing legislative protection within their country. He's also been instrumental in virtually all U.S. federal legislation enacted over the last 2 decades. He's also the author or co-author of numerous books on whistleblowing. Welcome, Tom.
Thanks for having me.
Our third panelist is Anna Myers. Anna is executive director of the Whistleblowing International Network, which has over 60 members and associates from 33 countries that share expertise and advocacy support. Anna works tirelessly to make sure that WIN fulfills its mission to strengthen the capacity of civil society to protect public interest whistleblowers worldwide by sharing legal and technical expertise across borders. Anna is a United Kingdom lawyer, although also a Canadian, and originally trained and called to the bar in Canada. Over Anna's career, she has advised countless individuals on whistleblowing concerns, trained senior executives and policymakers in public and private sectors on embedding sensible whistleblowing arrangements, and has advised numerous governments on whistleblowing law and practice. She has also worked on major international standard setting, legal instruments and guidance on the protection of public interest whistleblowers for the United Nations, the Organization of Economic Cooperation and Development, and the Council of Europe. Welcome, Anna.
Thank you.
And finally, I'd like to introduce our moderator, David Hutton. David is a senior fellow at the Center for Free Expression, and along with Ian and Anna, serves on the Center's Whistleblowing Initiative Steering Committee. David is a former executive director of the Federal Accountability Initiative for Reform, a Canadian charity devoted to whistleblower protection. As well, David is a trustee and one of the founders of the Whistleblowing International Network. David initiated with the Canadian Standards Association the development of a guidance on the implementation of whistleblowing systems that was published by the Canadian Standards Association in 2016. David has provided advice to, in addition to countless individuals, many organizations, governments, and to the parliamentary committee that reviewed Canada's deeply flawed federal whistleblower protection legislation. David, in addition to his advice to so many whistleblowers, has spoken and written extensively about whistleblowing, published in-depth analysis of Canadian whistleblowing laws and their implementation, and developed original guidance material for whistleblowers. And if any of you are interested, much of that material is available on the Center for Free Expression website, which is cfe.ryerson.ca. In any case, enough for me. Over to David and the panel, and thank you, and I look forward to your discussion.
Thank you, Jim. And after those introductions, I can't wait to hear what we have to say. I'm really excited about this session because of the enormous amount of experience and expertise we have in our virtual room here. Let's just dive in. We have an awful lot of knowledge here, and I want to make sure we make the best use of it for our audience in the limited time that we have available. So Ian, I'm going to start with you. You've done a tremendous amount of work in the past few years in digging into our provincial legislation and understanding what lies under the covers there. Can you, for our audience, can you give people a sense of the status of whistleblower protection in Canada, both at the provincial and the federal level?
Okay, yes. So as you know, but many of the audience members might not know, the first standalone laws appeared in Canada or were implemented in Canada in 2007. That's when they came into force. And that started at the federal level. Previous to that, there was nothing. Provinces followed shortly afterwards. All the laws that have been passed that are standalone laws have been for the public sector. There are a few sectoral laws, such as for Ontario's long-term health care, where you might have some protections, but they're not very comprehensive. In general, the level of protection is very low. There's a lot of common elements that span all the different provincial, federal, and territorial laws. It's almost as if they were cribbing off each other, sometimes almost article for article. You know, I would be reading the New Brunswick and I would be reading the Winnipeg or the Manitoba legislation, and sometimes even the numbering was the same. So when I speak to the laws, most of them have the same common flaws. At their core, they're considered what are called anti-retaliation laws, but they also address how wrongdoing the reported wrongdoing is supposed to be investigated. And they also have a stated purpose of keeping public confidence high. In general, though, they don't really do any of those things terribly well. The common flaws appear to be that the laws appear to be designed to channel the disclosures of wrongdoing, not to necessarily resolve them. And this is most obvious when you read the clauses about the purpose of the investigations. And the purpose of the investigations is almost uniformly to bring the attention of the wrongdoing to the organization and to make recommendations for correcting it. It's not actually correcting the problem, it's making recommendations. Beyond that, the laws tend to favor a lot of secrecy over the transparency. For example, the process is pretty opaque. If you're a whistleblower going in, you don't know what to expect. There's not a whole lot explained to you. And then as it's going on, well, they don't consult you really. I mean, they could, but in general, they often don't. The other big problem that I see with them is that all of them have almost absurdly broad loopholes, and this allows the investigating agency, whether it be a commissioner or ombudsman, to dismiss the disclosure with minimal reasons. The worst offending clause is the any valid reason clause, which allows them to essentially make up a reason if they want to. And because so few of these are actually reviewed by any other authority, that means nobody really challenges it. The corrective process, as I said, is very weak. All they can really do is make recommendations to the agencies. The agencies can ignore them, and then maybe the issue can be escalated one level. They can do reports. There appears to be the mentality that shaming the officials is enough. Whistleblowers are very unlikely to be protected. The problem with the protections that are there is that the onus is really on the whistleblower to get everything right or lose protection, to seek redress after the fact. There's no real-time protection. This is all after the fact. And sometimes the processes to get any kind of justice are tortuous. You go through various levels of appeal. You have officials with conflicts of interest, on and on.
I think we get the picture. Yeah. And you know, we're talking about the federal law. I remember when that was passed way back, one parliamentarian said, this is a law not to protect whistleblowers, but to protect deputy ministers from whistleblowers. And, you know, he got that exactly right, I would say. So, Tom, maybe you could, you have a tremendous perspective on what's been happening around the world for a very long time. And I know you've been doing a lot of work recently to compare different countries. Tell us what Canada looks like from your perspective.
Well, that's goes right to the conclusions of a study that I've been working on at the Government Accountability Project with the International Bar Association, and my partner Samantha Feinstein, who's participating today, to compare whistleblower laws both in terms of how the rights on paper compare to best practices for rules of the game, and how the laws have fared in practice. Are those rights worth the paper they're written on? And we did this because, you know, having worked with whistleblowers so long, it's become clear to me that whistleblower laws can have two faces. One can be a genuine attempt at free speech rights, and another can be actually an attempt to, instead of shielding freedom of speech, to shield those who are abusing their power that you want to challenge through freedom of speech. And those laws may tend to funnel all the whistleblowers into an audience that's got such a conflict of interest. It's like turning yourself into the wrongdoers as a predicate for having any rights. And then they always lose when they exercise them. So it becomes really a very counterproductive system that's kind of false advertising. And we kind of divide those up into saying the laws that are credible. I call those metal shields, because you know, if you go into battle with a metal shield, it's dangerous, but you got a fighting chance to live. Then the laws which are false advertising, I call them cardboard shields. No matter how beautifully they're painted, you're going to die. And I would evaluate Canada's law as a tissue paper shield. Out of the 48 countries that now have national whistleblower laws, or 62 if those swept in by the EU directive are counted, we rated Canada tied for last with Lebanon, having only passed 1 out of the 20 criteria for modern best practices. And that criteria was that they would have a review every 6 years, and they haven't done it. So it doesn't have too much to say for it. And I realize that's, you know, those are harsh generalities, but I'd like to back them up with some of the specifics. I can just give you, you know, a top few of them, top 10. Who's protected by the law? It's like you know, Swiss cheese with more holes than cheese. It protects some public employees. It doesn't protect the private sector, as Ian pointed out. But even within that universe, it doesn't protect those who assist the whistleblower. It takes a whole team to have a responsible disclosure, gathering the evidence, confirming the accuracy of things, knowing if there's supporting witnesses. If you just protect the final messenger at the moment of delivery and you don't protect the whole team leading up to it, there's going to be a lot of isolation, lower quality disclosures. It undermines the purposes of the law. It doesn't protect those who are associated with whistleblowers. Well, isolation is fatal for whistleblowers, and people can be fired and be defenseless just for being seen with a whistleblower. It doesn't protect those who are mistakenly perceived. It doesn't protect those who are about to blow the whistle, which allows preemptive strikes if you think somebody is gathering the wrong evidence. There's coverage loopholes for your audience. You can't even have any rights when you speak to a coworker about alleged misconduct to check if you can recruit a team. They turn you in, you're defenseless. If you survive that gauntlet, third problem is a prerequisite for your rights being valid is that your motives were in good faith. That means we put the whistleblower on trial, whether or not we're going to, do we like him or not? Do we approve of why he or she did it? Well, that's not the purpose of a whistleblower. They're witness protection laws. Some of the most significant witnesses in history were mafia hitmen who are murderers, but we needed their evidence and we need the truth from whistleblowers. The proper standard is they have a reasonable belief that their information is correct. The law doesn't cover civil and criminal liability, just workplace harassment. Well, you know, getting a multi-million-dollar slap suit or facing years in prison can have a more chilling effect than getting fired. 33 out of 48 countries with national laws have civil and criminal liability protection. 47 with the European Union, not Canada. Burdens of proof, that's the rules of the game. How much does it take to win? How much evidence does it take to win? If you don't have good burdens of proof, you can have arbitrary decisions. The judge can do whatever he or she wants to. Well, all credible whistleblower laws say that the employer has the burden of proof for its pretext. Hardly anyone, unless they're really slow, says, I'm firing you for blowing the whistle. They say, I fire you because you're a jerk, or you're a crook, or you're a harasser, or something else. Well, the employer has to prove that in credible laws. Not in Canada's law, the whistleblower have to disprove it potentially. They have 60 days to file their cases after they're retaliated. They might not even know they have rights in 60 days, let alone find a lawyer or access to court for the day in court. The commissioner has veto power over your access to court. And that's meant that he's turned down 350 out of 352 cases where people sought to go to court without explanation. They were denied their day in court. And why? Because dealing with the commissioner, who's the czar of whistleblower rights in Canada, is like trying to have a working relationship with the Wizard of Oz. The communications are all a one-way street. The whistleblower doesn't get entitled to any explanation what happened to his rights or his or her disclosure. They don't get to participate in the investigation if there is one. They don't get to know why there wasn't one. They don't get to know what happened to it. The bottom line is the agency responsible to shield transparency is operating in total secrecy. And it's been a failure in terms of its track record. There's no disciplinary accountability. There's a complete loophole for all intelligence agencies. That's where some of the worst abuses of power can occur. And 34 out of 48 nations with whistleblower laws protect intelligence community whistleblowers in one way or the other, not Canada. I mean, I could keep going, but that's the top 10.
Okay. So, Tom, it doesn't sound very good. Can I ask you, just to kind of put this in context, the other countries that we would normally compare ourselves with, other modern democracies, we are apparently in the company of Lebanon. How, as a generality, how do they rate under your examination?
Well, the top laws actually are other members of the Commonwealth. Canada's not in character. Australia, I think, has the top-rated whistleblower law. Ireland has an outstanding whistleblower law. Great Britain's has gotten a little bit dated, but even as a pioneer law in 1998, it was far stronger than what Canada has in 2020. The European Union directive is outstanding. It's setting the pace for modern freedom of speech.
Right, great, thank you. Good, well, I think you've set the stage nicely for Anna, because Anna's got a tremendous amount of experience working in Europe with governments and NGOs, and is living in Europe now, and has been heavily involved in the development of the European directive. So Anna, please tell us about what's going on in Europe.
Yes, thank you, David, and great to have this discussion with you and Tom and Ian. I think what has been happening in Europe has astonished many of those who've worked in whistleblowing for many years. About 3 or 4 years ago, there was an open meeting where the European Commissioner basically said, the European Commission, sorry, basically said, this will never happen. We will not have a whistleblower law. It is not within our wherewithal at all, and there's no legal basis for it. And in 2019, the European Union and the Council of Europe, so there's two sort of deciding bodies in Europe, agreed at the sort of final hour before elections actually happened. So there was a real push, agreed on the European directive. And what a directive does, and unfortunately, I'm in the bit of Europe that is desperately trying to cut the cord and sail off into the Atlantic. So at the moment, it is 27 European states. There were 28, of which the UK was one. And I think we were out in a month. But 27 European countries have to turn what is a broad and important and comprehensive whistleblowing directive into national rights. They need to do it not only at their legislative level, but there are institutional requirements. And I think that is one of the key things that I see. And there's a number of key things there. The detail of it, Tom has already raised what doesn't work, and many of those issues are covered in the European directive. So there is the reasonable grounds to believe. It makes it very clear in the recitals to the directive that motivations are not important. They're not important for getting through to the first level. So one of the problems with some of the Commonwealth laws, and the Public Interest Disclosure Act was this idea of good faith. And for non-lawyers, good faith is an interesting concept. It could be being nice, it could be, but it's meant to be being honest. It doesn't mean that you can't be mistaken. And it really means that you look beyond what somebody's position is about their motivations, but you look at what they're saying. And that's in the directive. It also covers a wide range of workers and people associated in work. So it covers the self-employed, it covers contractors and those within the supply chain of work. It covers the public and private sectors. I've been on a few seminars in the last year, and certainly since COVID-19, which I hope we will talk a bit about. The idea of whistleblowing has come to the fore in amazing ways. And there's also this idea that we now have until the end of next year to get these laws in Europe in place. So there is a lot of momentum to get it right. But one of the things that they very much looked at was the fact that it covers those in the public sector, those in the private sector, those in the voluntary sector. So we've had issues within the health services in COVID-19. We've had issues in the charitable sector. So all of these people will be covered by the law. But one of the things that came up that's very interesting is that all employers with more than 50 staff have to have a whistleblowing policy. And I think that is going to take Europe by storm. The idea that all workplaces have to have an arrangement which makes it clear who people can go to. The European directive protects you if you raise concerns with your employer, which is where most of the problems arise. But it protects you if you go outside the employer to a regulator or a law enforcement authority. There's some discussion about whether there'll be a single authority, because there is a lot left up to the nation states themselves to determine, because there's areas of law that the European Union can't go into, but they can give strong steers. And then, of course, there is the protection for public disclosures. And that is, again, another important feature of the European directive. That does work with the European Court of Human Rights, the European Convention of Human Rights and public freedom of expression. So in the end, one of the key issues for all of us, if you think about what, these are phrases that Tom knows well, and what Ian was saying at the beginning, laws that are really about sort of managing information, funneling information, those are information control systems. But whistleblowing is that sort of, that's that arrow that whistles over your ear that tells you there's something that you're missing. And it can't be controlled in that way. It is trying to ensure that information can get to the right people at the right time. And if there are any blocks, if you think of it like a brook with stones and you have a block, you're allowed to go around it. And if you think about our systems and our societies and our accountabilities, there are those who will be liable for the wrongdoing. So those will be employers, organizations, if it's found out that their organization, whether it's someone individually working for them or a system they have, is causing harm. They, of course, are liable. That is one route where information should go. But there are regulators, there are inspectors of our care homes, there are all sorts of authorities, law enforcement, who are also part of our accountability mechanisms. They have powers. They can go and do something about it. And then in the final analysis, it is the public who has a right to know. And one of the things that I thought I would raise here, because of course the European directive will cover this, and we've got this period of excitement, but also hard work ahead about ensuring that in 27 different countries, where whistleblowing itself is a concept that is known to varying degrees, is going to be implemented in practice. And I think this is not going to all end in 1 year. It's a long-term project. But when we looked at when we started to have the information about COVID-19, nobody was saying you should have to go internally first. We had people around the world working in our social care and in our medical establishments who were raising the alarm about issues and risks they were raising, and they were going directly publicly. So when you think about whistleblowing, those are the sort of three conceptual layers about where people should go. And the EU directive very much covers that. It also makes it, I was just going to say two more things. It also makes it very clear that people can raise things and their confidentiality is to be respected. And it also makes clear that those who raise concerns anonymously and report concerns anonymously, if their identities are discovered, they are protected as well. And it ensures, and for those of us who, and like Tom, and like those at the Center for Free Expression's whistleblowing initiatives, who are trying to set up and make sure that individuals have access to advice, it does say that the European nations must provide access to independent advice for whistleblowers. And that is key, you know, knowing what you can do, knowing your rights, knowing where you should go, and knowing what some of the risk factors will be, because as Tom says, a metal shield gives you a fighting chance. When you are blowing the whistle and perhaps going against what has become the status quo, you need support. You need to understand what the risks and opportunities are that face you. And you need the law ultimately to be backing that up. It is really about giving some, evening a playing field. This is a power dynamic in which you're trying to give the whistleblower, the individual, some ability to be able to survive what happens. And if you have all the people involved that Tom was talking about, and in the European context, we've had unions being incredibly involved in pushing for the directive, as well as the NGOs that deal with whistleblowing and transparency and good governance. It means that they are all part of the solution with whistleblowers. And that is, I think, for me, and what being in this space now for 20 years on this side of the Atlantic, that is huge. That now people are definitely not seeing whistleblowers as these isolated, perhaps not quite thinking about their own personal, you know, people do wonder why they've taken the risk they've taken. And we're starting to see that risk being slightly shared, the responsibility for public interest whistleblowing being shared by more people. And I do think that that's going to make a real change.
Great, thank you, Anna. And so that sounds very exciting indeed. You set the stage for talking more about COVID, which is a big issue for us all around the world, and especially in Canada, I would say. Ian, could you perhaps take us into, you know, some of the events that have been happening in Canada that to most of us would signal a clear need for whistleblower protection and how the authorities have responded to that. And I should just mention, for the benefit of Tom and perhaps Anna, that in Ontario, our largest province, there was very little understanding of how serious the problem was until the Premier called in the Army and had the Army go into about 5 or 6 long-term care homes. And bless their cotton socks, after having a look at that, they wrote a report which sets out the most horrific findings, which people were able to read in plain English. And without that step, we still wouldn't know what was going on. So anyway, I'm getting ahead of myself. Ian, I'll let you talk about this.
Well, you've introduced the topic already by bringing up the issue of the Army coming in. And I read that report as well, and it was written in very dry military language, which I remember from my days in uniform, but it really did convey a very powerful message. But this was the culmination of many years of neglect. It wasn't something that just happened overnight. Governments across Canada have been increasingly trying to push away oversight from their own offices and their own officials, their own inspectors, onto the industry itself through deregulatory measures. And it hasn't worked particularly well. In Ontario, for example, there are only a few inspections, I think 9 inspections in 2019 of all the long-term care homes. We had been hearing problems, of course, for years about poor care in the long-term healthcare facilities, but the protections in Ontario and in Quebec and in other jurisdictions just aren't really enforced very well. So if you're a whistleblower in a situation like that, and you're having to make a choice between complaining about something or losing your job, it's not a very favorable arithmetic to speak out. And I think that's allowed the situation to deteriorate to the point that it did, where the Army had to be called in. And that's just in Ontario and Quebec. We have no idea what it's like in Alberta or BC. I'm sure it's just as bad there.
Tom, Anna, go ahead.
Yeah, I was just going to say, certainly just the impact of COVID on the care sector and the and anywhere where there was both a poorly paid frontline staff. We've seen a huge amount of focus on that. I think it's been more of a political issue and a live issue in the UK over for a longer period. So I think there has been an attempt to respond, at least politically, quite quickly. But I think what we saw were care workers and staff there, and they're still fighting to really get the kind of focus on them. And the whistleblowing that came out of there in those early months was quite shocking. And it was quite amazing to also have the medical profession being very clear about the lack of PPE, the personal protective equipment. And we're still not there. I think one of the things, and I'd really be interested in Tom's view of this, but at least for a brief moment, and I hope that it can be, the momentum can be picked up, but there is that real sense of who is in our workforce essential, and therefore their ability to speak up about what's happening. You know, it's food supply. When you have a pandemic, we had our food supply being clearly questioned. We had our healthcare being clearly questioned, our public transportation, bus drivers, people who are doing cleaning work. That we've seen whistleblowing in those sectors in ways that we haven't before. And they are getting public support. There's been an immediate nexus, and the public can see the value of the whistleblowing. And it really is those moments that we need to sort of remind people what this has always been about. And we're also seeing real concerns about the money flows that were opened up. And in the UK, there seems to have been, certainly our current government in Westminster, there seems to be incredible contracts that just bypassed all the public procurement that normally goes on. And there's starting to be a real sense that the whistleblowing is only going to continue. We're going to hear more about how our governments weren't prepared and what happened. And again, it's how do you galvanize that, both to ensure that the people who are going to come next are protected and that we don't lose some of the momentum that we need to protect those who keep that information flowing so we can make decisions, both as individuals, but as members of communities and societies about where we think that the chips should fall and where we think things should be improved. I was going to ask Tom, because I'm very interested in what you think COVID has done perhaps to the whistleblowing discussion in the US. I know there's so much else going on.
Well, it's actually, for the most awful of reasons, created some real opportunities for stronger free speech rights in our country. We've worked to prepare, and it's been introduced, several bills introduced in Congress, a COVID-19 Whistleblower Protection Act, an Essential Workers Whistleblower Protection Act, that would give gold standard rights, not only to challenge corruption in spending or waste, but also anything related to public health, and not just COVID-19, but basically be a public health whistleblower law. Our country, unlike other nations, has a different law for every topic. We don't have one national one, but that's been kind of a loophole for us. So we're for sure working on that. And I think we have the wind at our backs for a few reasons. One is the leaders that we worked with preparing under Senator Vice President-elect Harris and Senator Warren, and their day seems to be coming in our country. The other reason is consequences. The impact that whistleblowers have had in our country. Like the U.S. has the worst whistleblower, record in the world, but it could be a lot worse if it weren't for whistleblowers. Just to the most symbolic level, Dr. Fauci has been blowing the whistle on President Trump, and it may have cost him the election. But getting down into more tangible whistleblowing, give a few examples. Dr. Rick Bright. He kept us from, having malaria drugs and bleach being mass distributed, not bleach, but malaria drugs being mass distributed in New Jersey and in New York. It cost him his job, but he may have prevented a worse public health disaster, and now he's on the transition team for COVID. Or there's one of our clients at Gap, Jay Brainerd. He's federal security director in Kansas to keep the airports secure and safe. And he blew the whistle because he just couldn't accept the TSA's practices were so sloppy in defying all the public health standards, kind of Trumpian practices, that the TSA had become the major vector for COVID-19 spreading during the first wave. And he traced it, and the hotspots all came from the airports, and the TSA people didn't have any masks. In fact, they were ordered not to wear masks for an extended period. They didn't have any personal protective gear. There was no sanitation between passengers. So the TSA people patted down or touched or took the driver's license from one passenger. They'd spread it to everybody else in the line or their luggage. Well, Mr. Brainerd, he was really worried that before the July 4th holiday, we were going to have a second wave caused by our government, his government agency. He, when he didn't get anywhere within the agency, he filed a disclosure under the Whistleblower Protection Act in our country. The whistleblower agency backed him. The media covered it. And within a week of his disclosure, the TSA administrator met with him and customized a reversal of all the violations of CDC public health standards. And our government workers stopped being the cause of the pandemic. Of course, there's other causes. And it goes along, there's whistleblowers who have been exposing from scientists to prison guards, how the prisons are becoming a vector that spreads the pandemic into the community, from the poor public health standards for the prisoners to the guards to the rest of the community, or the immigrant detention centers, like in the course of challenging the public health violations that they undercut control of the pandemic in hospitals for immigration detainees. Whistleblowers expose human rights abuses like the uterus collector, the mass hysterectomies of people who are being exposed to COVID-19 through inadequate public health standards. They're there as the public's eyes and ears with life and death consequences. And that's what's our mandate for getting stronger rights, is when we can show this makes a difference in people's lives, and continuing them is the strongest argument we can make.
Tom, thank you. And I mean, a lot of the things that you and I are describing, undoubtedly, we know or suspect are happening in Canada, and yet their success rate of whistleblowers here is very, very low. And the fate of people who have come forward and it has been very unsatisfactory. I just want to remind our audience that we're going to start responding to your questions soon. So please, I know that Jim is listening. Jim, do you want to give our audience some instructions regarding the question and answer process?
Yes, thank you, David. If any of you would like to ask the panel questions, you'll notice down at the bottom center of your screen a Q&A button. Simply click on that at any time. And if a question comes to mind while they're talking, you just write the question, and then in a little while, David will turn to the questions and ask the panel the questions that you put down there. So if you'd like to ask a question that's come up already, write it down and put it under the Q&A button. And if you think of other ones as we go along, please add them and you'll have a chance to talk with the panel, or the panel will respond to your question. Thank you, David.
Thank you. And I'll ask Anja. Anja, have we got any questions that are sitting there waiting to be answered right now?
Yeah, we do have a couple questions. There's a question for Anna. This is from Samuel, and Samuel is asking, what are your thoughts on the limited to no legal protection for whistleblowers working in long-term care homes?
The limited to no legal in
long-term
Canada?
care.
Right, and in Canada?
I would assume so.
Assume so, yeah. I think this is one of the key issues in countries where there's been, and Canada is one of them, and it is a conundrum to me, because if one thinks about whistleblowing and where things can come up, they can come up in any organization, in any workplace. And so one of the gifts of the law in the UK was it was part of employment law, and employment covers every single worker in the UK by definition. So it just, there was no public-private distinction. And I think that, we've had in Canada, there's sort of the focus on the federal government and a law that really is, I think, something that is just not about accountability. It is about information control. And we haven't had enough focus on workplaces outside of that. Now, I work for an NGO. I worked for non-governmental organizations and charities for most of my legal career. And the idea that charities or third sector or nonprofit organizations are somehow not the same as other organizations and can get things wrong, I think is really untrue. And so whistleblowing laws have applied to where I've worked as well. And I think the idea that in long-term care facilities that there isn't clear protections. Now, there should be already all sorts of other rules and procedures and safety and reporting mechanisms around care. And in many of our countries, there will be other laws that you can call on. But if you're not messaging that so clearly to staff, and I know because I have had relatives in Canada and have relatives now in care facilities and may turn into long-term care facilities, there is a number of contracting staff working there. The way that it's set up can be very difficult. And I think this is one of the things in the EU directive is really clear, that there is no one that is not covered by those laws. And then the focus, it needs to be switched very quickly on those employers to be saying, what are you telling your staff about how they can speak up, who they can go to, how they will be protected, what will happen to the information, what are the duties back to the individual, and where else can they go if we're getting it wrong? And that's the sign of a very strong organization, and one that staff will believe in. If the organization itself says, this is so important to us, the care of the elderly or the vulnerable that we are set up to look after is so important to us that if for whatever reason you think you can't raise it with us, here is the number you can call for the health authority or the oversight locally, because that is, again, that gives the confidence to the individual staff that they will be listened to. but we also need to have those alternatives there in case they're not. And so it has to be real, not cardboard. And I think it's very, very important that these people are covered, and we can see it now. It's just so clear.
Anyone else? Okay. Any other questions, Anne, right now?
Yeah, sure. We have, Mary was asking, she would like to get the panelists' views on the 2 Canadian programs that pay monetary rewards to whistleblowers. So there's the OSC program and as well as the CRA's offshore tax informant program.
So Ian, do you want
I
to?
can't comment
Sure,
on
yeah.
specific.
There's a lot of promise in incentives programs that offer bounties, particularly in sectors where people are paid enough money that the incentive may be more to cheat or to stay silent. There's not a lot of track record in Canada yet. The first law was, I think, in 2013 was the Ontario Securities Commission, I think it was. And they haven't gotten much yet. Investigations take a long time. But even so, I've been a little disappointed at how much has come in. I can't give exact reasons why that is. And maybe that our financial sector is a lot smaller than the US. It may be also that we don't have a single national securities regulator. It's almost impossible to put one in place. The provinces are always bickering about whose rules should be followed. But I would think certainly in the private sector, this would help tip the balance for many whistleblowers to speak out if they knew that they were going to lose their jobs as a result of it. Unfortunately, if you're in the financial sector and you blow the whistle, you can pretty much write your career off. And that's the reality anywhere.
Tom, you were wanting to say something.
We've had some experience with the bounty laws, and Canadians are eligible to make whistleblowing disclosures and seek bounties under the Dodd-Frank law. In fact, Canada is one of the countries that makes the most disclosures. I'm not a big fan of them. To start with the reason I'm concerns about them is that at least a government accountability project, I think with a lot of the NGOs, our first principle is to protect against retaliation, do no harm when you're working with a whistleblower. And the bounty laws have made it harder for us to champion free speech rights because instead of being kind of the profiles encourage, the employers paint the whistleblowers as, Judases, whispering in government's ear to get money for it, betraying their community to get money. And so it makes it harder for us to advocate. And then it makes the employers more paranoid. They're much more nervous. And the studies have shown that the rates of retaliation have increased significantly in the U.S. In the corporate level since we passed the Dodd-Frank law, even though it included very strong whistleblower protections in it. So I'm not sure that it helps whistleblowers that much. I think it's been a lot more beneficial for whistleblower lawyers. They love it because it's easy money for them. They can just write up the charges and let the government do all the work, and then they get a percentage of their client's bounty, and plus they get the time that they spent writing up the charges. And boy, whistleblower law firms were popping up in Washington, D.C. like weeds in the springtime after the bounty law was passed. But I'm not so sure that it really helps the whistleblowers. And it has brought in a few $1 billion since in the last decade. But I think a superior model that does involve commercial recoveries and actually a lot larger ones is our False Claims Act. That's the law that empowers whistleblowers to file whistleblowing lawsuits and fight and win the battle against fraud on behalf of the taxpayer. They don't just talk to the government and let them take over. They file the suit. The government can join in and take the leadership in it, but the whistleblowers are on the front lines. And that hasn't sparked a backlash because it's people who pretty much given up their career to fight the lawsuit. And it's also been much more effective. We've gone from about $10 million a year in civil fraud recoveries for government contractors in 1986, when this law was born again, to over $1.5 billion a year now. Thanks to whistleblower lawsuits. And it's getting better and better. It's been over $3 billion for most of the last 5 years. So there is some opportunity to make money from whistleblowing, but I don't think that it should be through bounties. I think it should be through fighting and winning battles on behalf of the public and breaking the government's monopoly on law enforcement, setting up a citizen enforcement channel for freedom of speech.
Thank you, Tom. By the way, Tom, we're having a little bit of I'm getting some breakup of your voice, so I'm not sure if there's anything changed at your end, but I'll let you have a look at that. Anna, I know that the European directive has steered away from this sort of monetary incentives. Can you tell us what's going on there?
Yeah, I think there's a similar, there has been a kind of, I think, visceral reaction against paying people for whistleblowing. So one of the things that went into the Public Interest Disclosure Act, which is the UK law, at the beginning was one of those things of, you can't get protected if you're being paid for your information. So that was really in response to tabloid press paying people. And it's sort of saying if you're going to get recompense one way, then you can't seek protection the other way. And that makes some sense. I think the issue in Europe has farther to go. Whistleblowing itself, and despite this incredible success, and Tom was very helpful and did a lot of advocacy at the European level, very much, and with me, and trying to explain with so many other people about what could go into it from years of experience, and even David, all of your experience at FAIR, there are key things that need to be in whistleblowing laws. And to go to rewards, which does sort of create a different conversation. You have to put in different parameters. The False Claims Act is a very specific one that the US has taken. Qui tam is an older concept, and it does come originally from Roman law and British law, but it was taken and given renewed life. And this is this idea of you having agency as a whistleblower and taking the claim and then reaping the rewards of that. But in the model of giving rewards, often, like in some of the laws we were talking about, which we start to see as putting up barriers, often there are parameters so that there's very distinctive ways in which you can get that reward. And a lot of whistleblowers will come forward and they'll never have any chance of a reward, and they'll still be helping the government agency do their jobs. One of the things I remember with one of the original or the early heads of the whistleblower unit at the Securities Exchange Commission said is one of the, still many of the people that go there aren't doing it to get rewards. So here, if Tom has looked at that evidence and said, actually the rewards have increased the likelihood of retaliation, then most of those whistleblowers may be facing more retaliation and not getting the reward that would recompense for that. What we really think is it will start to change the game in Europe and should be pushed even further is this duty of care that employers should have, because protection is a funny word, right? If you think about it in a legal point of view, we talk about protection against sexual harassment. It doesn't say it's going to stop a sexual harasser. You hope it does, but you understand that it's something that you can use to stop it. And in whistleblowing, the idea of protection doesn't help you as a law that says, you can go later and get some recompense back or be put back into a position when things have already gone wrong. And this is a really important, all of us in our workplaces, there may be people you have jobs they don't particularly like, but it takes up a lot of your life. Often it is where you've developed your personal relationships, professional relationships. A lot is at stake when suddenly you're seen as a problem in a place and you're putting that at risk. And so the laws are really been designed so far to deal with the piece of the puzzle, which is really important, that we say that when you're speaking up in the interest of others and you yourself suffer, you should have a remedy. And we should start to change the culture. But the culture of a workplace really changes when the employer says, we'll actually get in trouble. not that we'll be fighting individual cases and that we can individualize the problem and say it's just this one person. When it is, the duty is on us and we could get in trouble. And I don't necessarily mean criminal liability, but I'm saying, you know, you could get serious fines, and not just for failing to protect one whistleblower, but failing to have a system that anyone believes in and that works. That's where we're starting to see some change. And I think that's where we're starting to get in a more mature conversation when when we've seen it not working, is that actually if we have to hold those who are accountable to account, not just put the onus on the whistleblower. And there has been some ease around passing whistleblowing laws and then everything else not being there for the whistleblower. And I think this is where all of us are waking up, and we're pushing more on this idea of employers having duties and being actually held to account, not just for the individual whistleblower case, which they definitely should be, but for failing to provide the systems that anyone can believe in and for undermining them. One of the cases, I'll just throw this out and then I'll shut up. One of the cases that I think, again, hasn't changed the world, but did send a shock, I think, in the UK financial system, was when Jess Staley, who was the, I always get it wrong, CEO of Barclays Bank, there was a whistleblowing system, you know, since the crash. There's been lots of systems in banks. They got them really well done, I think, in lots of levels, but they still sort of, the heads of those organizations still don't think it's about them. And there was a whistleblowing case that came through their systems that was close to Jess Staley and his team. I believe that the actual disclosure wasn't found to be particularly, it wasn't ignored, but it wasn't found to be a serious issue. But the system kept that individual anonymous to those around them, so kept them confidential. And Jess Staley tried to find out who it was. And it was ended up being fined, but more seriously fined in the US. So the US is very good at fining the organization. And Jess Staley was fined personally by the Financial Conduct Authority in the UK, and what the organization was fined in the US. And that's because they were undermining their own system. And I think that is where we need the next stage. If we can get the first stage right, we need to get there much quicker. Canada has a great chance to like leap over a few sort of few of the phases that the rest of us have gone through with getting there slowly. We've got some incredible examples around the world. We've got some real international best practice consensus, and Canada could kind of run ahead of us all very quickly if it wanted to.
And I'll just add a word to step out of my moderator role for a minute and give an opinion here. I'm one of the people that reacts kind of viscerally to these suggestions, and not from a position of lack of knowledge, because I've spoken with hundreds of whistleblowers, but it's the idea that you somehow have to pay people to come forward. My experience is that in every sector, every organization, every country, there are people who will come forward when there's wrongdoing going on, even when they know the cost to themselves may be very, very serious. People who come forward out of conscience, and nothing will stop those people. The tragedy is that we don't protect them, and the wrongdoing continues. And the analogy I make is, if you're in a battle and you're sending your troops over out of the trench to try and tackle a machine gun position, and they're all being mowed down before they even get near. Well, the answer to that problem is not to find incentives to send more people over the wall. The answer is to protect them so that they can actually accomplish the mission. And that's how I see whistleblower protection at the moment. So any other questions, Ange?
Yeah, there's quite a few. The next one is from Marcus. And Marcus says, Ian, Jim said in his intro that you are a former whistleblower. Briefly, could you share what happened to you and tell us what kind of legal protection would have made a difference?
Well, that's a really good question about the legal protection would have made a difference. Certainly not this law, the law we have now. I blew the whistle on misconduct at Transport Canada. We were developing regulation for the security of the maritime sector. I picked up a number of irregularities. Regulations weren't being properly drafted. Enforcement wasn't being properly done. There were inappropriate relationships between members of the government and people in industry. So I took my concerns forward internally, and the response was just decidedly negative. It was more of a brush off than bad. But when I left the organization, I really blew the whistle to a couple of agencies. At the time, there was no law in effect. There was a policy, but it wasn't effective in my case either. The reaction acted as if I had dropped a bomb on the building. The senior management team came together for a week-long session on how to deal with my whistleblowing. I heard this secondhand, of course. And then the way they came after me was first to try to attack my security clearance, and secondly to claim that I was harassing my bosses by making the disclosure. So it was this perverse situation where they're investigating me for harassing my bosses, and whether or not it was harassment, of course, depends on whether what I'm saying is true or not, but they didn't want to look into that. So they more or less came to the findings that I had, yes, indeed, harassed my bosses by making this claim against them. And it was a multi-year battle. I went to court. I unfortunately set a precedent where other public servants can't sue the government now. It was a life-changing slog. I mean, they came at me from every direction. They isolated me, all the things we've been talking about here. I had people who were backing me up at the beginning, but when they saw the reaction, they panicked and backed away. And many whistleblowers can fight for decades in their cases, and I think at a point, some whistleblowers just argue it isn't worth it anymore. I need to get on with my life, which is kind of what the organization wants, really. And that's what I ultimately had to do. I look back at it and I ask myself, did I make a difference? No, I probably entrenched the people who were there. That's just the way the system worked at the time, and probably still does.
Thank you. Ian, I'd just like to add that I know quite a bit about this case too. And Transport Canada is just one of the many departments that we've seen displaying problematic behavior. And in my mind, there's almost a straight line connection between the situation that Ian was in and the Lac-Mégantic disaster. Where there was a derailment of a big oil train, and a whole small town was basically incinerated. Maybe 50 people died in the flames, and it was like a small nuclear explosion. And the management system in place, the philosophy, the whole way that disaster arose, it was pretty much identical to the situation that Ian is describing, and which also incidentally applies not only to maritime, but rail, but also to aviation. And so we have huge concerns about that. And how are we doing for questions?
Can I just jump in really quickly? Because what Ian was saying about the timing and what the reaction was. So when we talk about things in law, like the reverse burden of proof and the burdens of proof that Tom mentioned, what needs to happen in that kind of case, if you are then going to court to try and prove, if you have to prove that the harassment is to do with your whistleblowing, so you're having this kind of strange thing where you're having to disprove everything they're saying and then prove what you were saying. It is absolutely key that showing that timeline, which obviously shows a prima facie case, like it smells pretty bad. And if it smells pretty bad and you can show you've raised something and the smell is there, then it's up to the employer to prove that this smell was not what you think it is, and it's a pretty smell and it's a valid smell and it comes from something else. And that's what a reverse burden of proof does in a court. It says that the employer must show that not only was what happened, with the action they took was fair and just, and they can show it, but it has nothing to do with the whistleblowing. Because every case you have, and we're dealing with one international case now where an individual blew the whistle on corruption, and his employer took him to court for defamation for blowing the whistle on corruption. Now, that is in a different jurisdiction because it's a cross-border case, and so they dealt with it as a straightforward defamation case, but he had to fight that case, and it's so obvious, and there was a criminal complaint against him, and he's now been arrested, I mean, years later, and the British Parliament had questions today, and the minister stood up and said, well, we are not shown yet that the criminal claim against him has anything to do with his whistleblowing, except it's a year after he blew the whistle on one of the biggest bribery scandals, and it's that employer that put the criminal complaint. So it's really important that we as lawyers explain why these need to go into the law, but Ian just said it, why it needed to go in the law, and this is how retaliation works. Tom,
you were going to say something.
Yeah, in the US, the point that Anna made about the time lag, it actually is a good part of our whistleblower law. If there's an action taken against you within 2 years after you blew the whistle, you've met your prima facie case. And the EU directive, which isn't applicable for the tragic case study she's been summarizing, doesn't even require that causal link at all. If you've blown the whistle and something happens to you, then the burden of proof shifts to the employer that their whistleblowing wasn't connected in any way. Even if they would have made the same decision, it can't be contaminated by whistleblower reprisal. Just one reason I think the EU directive is so good. The points that she made earlier about preventing retaliation, I think are very valuable to be on the record in this discussion. When somebody comes into GAP and wants to blow the whistle, my first duty is to try and talk them out of it. Not because I'm trying to avoid this or even want to succeed, but because they've got the right to make a fully informed decision what they're getting into. This is going to be war. War is hell. And are they prepared to go to hell and back for their concerns? Because if they're not, they'll end up reinforcing the misconduct because the organization will weather the storm against them. And they'll guarantee that they'll be crushed because they even tried. If they even stuck their neck out, it'll be cut off. So they have to be sure they're willing to make that sacrifice. And then if they are willing to follow through on this and push them as hard as possible, try and be a problem solver with this instead of a dissident. The best way to prevent whistleblower retaliation can come from whistleblowers. Instead of going in and saying, you're a crook and I've caught you and you're not going to get away with it, to come in and say, I'm concerned about the liability that we're facing. Have we considered this? What would be the impact on the value of our stock if there were suits filed against that? And that's very, it may go against some basic instincts, but actually it's consistent with most whistleblowers' perspective. They're not blowing the whistle to look for trouble. They're blowing the whistle as a matter of their personal identity, to be true to themselves, their professional pride and standards, that respecting their responsibilities that the organization told them they were supposed to be enforcing and honoring. They're not looking for trouble. And most of them they're engaging, not in the freedom to protest, but the freedom to warn, the freedom to prevent avoidable disasters before it's too late. And that means they should be the most valuable resource that there is for organizational leaders. Thanks to whistleblowers, organizational leaders can find out about impending disasters before it's too late. And they're the ones being blamed by something that was concealed from them potentially. And all they can do is pick up the pieces or damage control. And this isn't just, like New Age enlightened talk. This is grounded in hard, tangible business judgments. Professor Kyle Welch of George Washington University did a study of corporations that have whistleblower protection programs. They consistently had lower levels, less enforcement actions against them by the government. When there was an enforcement action, the penalties were lower, and the litigation settled more quickly with lower penalties against them. PricewaterhouseCoopers did a study of fraud against corporations, found out that whistleblowers are responsible for exposing and catching more fraud against companies than internal audit departments, compliance departments, and law enforcement combined. It's bad business to kill the messenger. And I think that's our challenge. Having legal rights against people who are anti-enlightened, and repressive and crude instincts to destroy anything that's threatening them. We need the laws for that. But what's really going to make a difference for freedom of speech is convincing those in authority that it's a resource, an invaluable resource for them, rather than a threat to their power.
And how are we doing on questions?
Yeah, we got lots of them. So the next one, somebody is asking if you could please talk about where the line is between supporting snitches and supporting whistleblowing.
Who wants to take that?
I was going to say, when I first started working in this field 20 years ago, I used to be able to go into a room, and we would, at Public Concern Work, which is now called Protect in the UK, we would do a lot of training with organizations. And I would just say, so, you know, who likes the word whistleblowing? And it was even better at the top of organizations, like with a board of directors than with staff. And the whole workshop would happen. I could be, you know, I could have drunk a bit too much the night before and it would happen, because even the word caused lots of reactions. So snitch is one of the words. The one that I learned when I moved to the UK is grass, snake, traitor. You know, I was just talking to somebody and doing a workshop with people in South Africa, and in Pipi, the informers in former fascist states. You know, in Germany, there's been a real resistance around whistleblowing, because if it is about people going to authorities, and authorities are the only ones with the information, and it's anonymous, and it gets to be used by authorities against other people, well, we want nothing to do with it. So that word in itself, saying what is the fine line, I think it depends on your perspective. And I think what we really want to do is say it's not about what I think. So I remember being asked if I thought Snowden was a traitor or a hero within a few days of it really, the story blowing up. And I said, that's, you know, I'm a bit tired of that question. The question I ask is, did I want to know? And it's like, yeah, I did. And why did it have to be him? Because nobody else was doing it. And so, you know, the word snitch, it is loaded, and I'm sure it was asked with that in mind, but every culture, you know, you ask what the word they use and what the word that really gets used, and it's been really interesting. So in French, it was donneur d'alerte was the first one, lanceur d'alerte. So throwing the alert. In Dutch, it's klokkenluider, which is bell ringer. These are all words that civil society have used to try and neutralize it, so we can get past that and talk about what it is that we are trying to protect and why.
The difference, but there is a relationship between whistleblowers and leakers. There's some overlap, but they're fundamentally different.
Tom, we're having difficulty with your sound again. We're having a bit of difficulty with your sound. It's breaking up again.
Is this better for sound?
I'm not sure, but keep going.
Okay. A leak is an anonymous, unauthorized communication of information. It means you're secret and you don't have permission. It might be anonymous whistleblowing, or it might be anonymous gossip, but it can include whistleblowing. Whistleblowing is using free speech rights to challenge abuses of power that betray the public trust. And that may include an anonymous, unauthorized disclosure. So leaking is a subset of whistleblowing, but they are different concepts. And Anna's point about the cultural barriers, I think it's worth sharing. The conflicting valid but conflicting values that whistleblowers have to sort out. You know, we don't like snitches and tattletales and rats and squealers. But on the other hand, we don't have much respect for people who say, I don't want to get involved, or I see nothing. You know, see no evil, hear no evil, speak no evil. That's a monkey, not a human being. Well, whistleblowers have a tough choice. Am I going to be a rat or am I going to be a monkey? How do they resolve those conflicts? They resolve them by speaking out because they have to be true to themselves. Whether their motives are noble or nefarious, if they sat on that information, it would be like a cancer eating away at them for the rest of their lives, thinking, well, if only I'd had the guts to do something with what I knew.
Okay. Ange, keep going.
Yeah, sorry. The next question is from Natalie. I do want to say, Tom, your audio was still a bit breaking up there or whatever, so I don't know if you need to make sure that your cables are plugged into your computer and nothing's on top of your laptop. Because this is for a question for you and Anna. Natalie asked, given how bad the Canadian federal whistleblowing law is, what advice do Tom and Anna have based on their international experience on what could get the government to bring in stronger whistleblowing protection?
Read the report, the parliamentary report. Tom, do you want to have a go? A lot of us helped and gave some good advice to a parliamentary committee, and it's a really great report, and somebody should read it.
I think anyone in Canada who cares about this issue also should thank David Hutton. He was the spirit behind that report. It's an outstanding report to basically recommends best practices across the board for Canada's whistleblower law. It would be a whole new generation and a different identity. You'd have free speech rights when and where you need them to the people who need to hear the truth. You'd have fair burdens of proof. You'd have access to court with due process, guaranteed day in court, under the same standards for enforcement of any other law. You'd have rights if you won your case, so that you wouldn't still be losing after you've won. This would, the recipe is all worked out. They just haven't brought it to the kitchen yet. It was an outstanding vision to bring Canada from last to tied for first, but it's dormant, it's gathering dust.
I'd like to, thank you for that question, and I'd like to build on it, if I may. And that is that, you know, I think I can speak for many of us here when I look at the truly appalling situation that we have in Canada when we're right at the bottom of the heap internationally in terms of our protections, federally and across the country, provincially. And when I look at other countries and how they've gotten better legislation, it's often been through a series of disasters or scandals that forced the politicians to work. And we have no shortage of those. You know, we're going right to the tainted blood scandal years ago. And right now we have a scandal going on where the Prime Minister and his party is up to their ears in a scandal to do with a charity. We have Lac-Mégantic. You know, the list goes on and on. Phoenix, the payroll project, which meant that we were unable to pay our public servants and are still unable to do it properly. You know, the list goes on and on. All of these have connections to whistleblowers being and employees' concerns being ignored. And yet still, we're at the back of the bus. So sometimes we feel, you know, are we ever going to get there? When just to go on a bit further on this, in spite of the horrific situation we have in Ontario and across Canada with the COVID pandemic, and all the signs being that we're going to do just as badly in many of those long-term care homes in the second wave, we have a premier who's saying that a recent whistleblower, we don't need whistleblower legislation, we just need to give this girl a job again. So we seem to have roadblocks everywhere and absolutely no political appetite for doing anything. Give us some hope.
If I could chime in quickly, David, you're absolutely right. It seems to be bleak. If I look at the way whistleblowing laws have been passed in many countries, it's after a scandal. But I noticed that in Canada, it's either when the government is weak or they're trying to signal that they're following everybody else's rules, but in which case they take something that doesn't work very well to fill the hole. Yeah. I
think one of the things, obviously I'm biased because I'm working with Ian and David and Jim and Ange and with support from Tom with the Center for Free Expression and Whistleblowing Initiatives. You know, there hasn't been there have been a number of very loud voices and David has been one of them for many years and Ian as well, but there hasn't been strong, concerted, sustained focus on what the connection is by NGOs and civil society with public support. And I think some of that making the connections for people really hearing about the individual stories, because obviously it is so important, and that does hit home when you see people just who do the right thing and it doesn't work for them. But I do think all around the world, and Canada isn't alone in sort of these issues coming up more and more, we are seeing a very much louder and a very sort of, what would I call it, in the nonprofit space. You know, you have some of the big players like an Amnesty International or Red Cross, or some of those players who Canadians, I think, do, you know, they are important voices in Canada as well. And I think it's up to those of us in these organizations that can make the connections to really start to reach across and create a louder voice. Because we are seeing in Europe a number of players coming together and seeing this as something they need to carry forward together. So it is organizations like the Center for Free Expression, along with unions, along with the legal profession, seeing this is an important bit of law that's not working. And then you do need some politicians who will really take it forward and see it as something that they can make a difference with. I mean, that committee that a lot of us gave some advice to, were very much of the view that they were just gonna maybe look at this and tinker with it. By the time they had heard from David, from Ian, from other people who gave really clear examples and saw what was happening in the rest of the world, they were saying, no, we need to start again. And that was a real turnaround in the few months that the committee heard some evidence. So I don't think that it's impossible at all in Canada. I think there's just getting together, making those pieces come together more often, and those connections to be made more quickly. And it is something that people start to see as a solution, rather than this odd thing that, as you say, Ian, is getting imported from somewhere else and doesn't apply to us.
Can you add a little bit to that? Because we've pushed to get so many whistleblower laws passed, and it's been very frustrating. It took 13 years to get the latest generation of the U.S. Whistleblower Protection Act. It kept getting killed in the back rooms and things. And kind of the lessons I've learned is that, if in real estate, the magic word for success is location, 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 with whistleblowing, it's consequences, consequences, consequences. That and solidarity. And so what we did during those 13 years is briefed all the different stakeholders on the consequences for their mission and the people that they're committed and dedicated to, from not having whistleblowers being listened to in the safe channel to warn, with the kind of examples that you've been listing, so familiar with. And then we had, besides other advocates, we had a petition for all the different stakeholders and NGOs and community organizations and companies, and how many members they had. And by the 13th year, we had 400 organizations with 80 million voters. And when I'd go in to push for that whistleblower law in Congress, I wasn't speaking on behalf of some courageous dissidents. I was speaking on behalf of 80 million Americans who are demanding this. And that's when the truth becomes politically powerful.
Okay. We're almost out of time. We maybe have a chance for a 1 minute or two on one last question. Do you have one, Ange?
Yeah, so this is a question from Art, and Art is asking, are there any whistleblowing protections for members of police, armed forces, or other emergency measures personnel when tasked with an intervention with the Canadian public?
The general rule is, if you're not sure, there isn't. The number of places where you'll find effective whistleblower protection in Canada is minuscule. You need a magnifying glass to find them and know where to look. So I can answer that the answer is no. I can say that fairly confidently. I think I should turn to Jim now to begin to wrap us up here.
Thank you, David. First of all, I'd like to thank the panel. This has been a very stimulating. All of you are amongst the leaders in the world on issues of whistleblower protection, and such an honor to have all of you sitting on our panel today. And I want to thank the audience. There was a lot of interest. There were a lot of questions we didn't get to. someone did ask a question, if what could they do to get an answer to the question if they didn't get a chance to ask it. So you could send an email to the center. So cfe@ryerson.ca, cfe@ryerson.ca. So send your question, then we'll pass it on to or get an answer one way or another for you. Also, there's been a lot of reference to the Federal Parliamentary Committee report, which looked at the federal whistleblowing legislation, which is called the Public Servants Disclosure Protection Act. Unfortunately, it doesn't do what the title suggests. But the parliamentary committee that looked at it does give a pretty good recipe of what the problems are and what needs to be done. So if any of you is interested in looking at that, you can go to the CFE website, which is CFE, Center for Free Expression, cfe.ryerson.ca, and just in the search function, type in the acronym for the act, P as in Peter, S as in Sam, DPA, and it'll take you, I think the second item you'll see is an article by David Hutton about the act and the key elements of it. You can also see the actual report. You can see the report of the committee. So David Hutton in material on our website summarizes it, but you can also see the actual report of the committee on the federal government website. And all you need to do is Google Canada, Standing Committee on Government Accountability, and PSDPA, Public Servant Disclosure Protection Act, PSDPA, and it'll take you right to the report. It's worth reading if you're interested. But again, thank you to all of you, the panel and the audience. Our next event the center is putting on is next Tuesday, a week from today, and it's a very different kind of event. The title and the topic is Anti-Black Racism and Inequality, What is to be Done? It's going to be a conversation with Adolph Reed Jr., who is one of the leading African-American public intellectuals and is a professor emeritus of political science at the University of Pennsylvania, who's been specializing for most of his life in issues of inequality, race, and racism. And he'll be in conversation with a Ph.D. student at York University named Umair Muhammad, who is the author of Confronting Injustice, Social Activism in the Age of Individualism. So it'll be a wonderful opportunity to hear one of the leading thinkers on the challenges of anti-Black racism and inequality. It'll be next Tuesday afternoon, November 17th at 4 p.m. There's information on the CFE website. So again, thank you to all of you for attending, and thanks again to the panel. Goodbye.
Good night.
Thank you. Good night.